I've had the experience more than once, actually, of sitting down with highly sophisticated plaintiffs, with really smart, intelligent attorneys, and we map out, we diagram out the structures, and we slide that picture across the table and go, there's what we got. You can have what you can find. So for a minute, we need to think about single owner entities. Risk can come from two directions. It can come from inside the entity, internal risk. So that's risk, for example, if an entity owns a rental property, risk associated with that rental property inside the entity. And risk can come from outside the entity. Things that have nothing to do with that rental property. Personal liability, car accidents, business things that have nothing to do with that particular entity. And single member LLCs were designed to contain internal risk. So the liability occurring on the inside of the LLC generally will not get out. But liability from the outside has a severe risk of getting in. And in fact, these single member managed LLCs get clobbered in the courts every day, in the civil courts and in the bankruptcy courts, because it comes down to this. The plaintiff says, look, Your Honor, it's the same party as the member and the manager, and we have a judgment against them. Why shouldn't we be allowed to get their stuff? And the courts go, yeah, good argument. Okay, we'll let you. Candidly, in my experience, bankruptcy attorneys are loath to dispute that. They are used to being taken advantage of by the trustees in bankruptcy court, so they cave in and they don't fight back. Plus, another significant and critical factor is to look at who is the manager, because one of the ways these single member managed LLCs get sabotaged is the court won't give the plaintiff explicitly the power to grab the money out of the LLC. What they'll do is they'll appoint the plaintiff as the manager. They'll say, you can be the manager now. And then once the plaintiff is the manager, with their judgment, they pull the assets out of the LLC and they apply them towards the judgment. So there's some things we can do, and a lot of that requires proper structure and proper documentation. And if you don't have the documentation, it doesn't matter what you've done with your LLC, you don't have asset protection. So one of the crucial factors that we've looked at is the LLC, or the partnership for that matter, has to have more than one owner. 2 owners at least, 3 are better than 2. So who should those owners be? Should I name my brother, my sister, my mom, my dad, my son, my daughter, a family member as an owner? And the answer is generally, with rare exceptions, no, that's a bad idea. Here's why it's a bad idea. People have people problems. They die, they get sick, they become incompetent, they make bad decisions, they have their own personal liabilities, and you don't want their life hang-ups and drama to cause problems for your company. So it's better to have the second owner be another entity. And what should that entity be? It's very powerful and effective if that second owner is a special kind of irrevocable trust, a trust that's outside the taxable estate of the primary party and unavailable to the creditors of anybody. And we can create those kind of trusts if you know how. Now we have very strong powers. And here's the deal. If person A and person B are partners and they get sued by person C, and person C comes and says, I want to take away the partnership of interest of person B. What does that make person C with person A? A partner. And person A has the right to say, I don't want to be your partner. You sued person B that was my friend. I refuse to be your partner. And the law at the moment cannot compel you to be a partner with somebody you don't have a deal with, you haven't agreed to be a partner with. And especially if you've done your documentation for your entity correctly, the current partners to the entity, whether it's an LLC or a limited partnership, have the right to exclude entry of new members, which means that the plaintiff out here who wants to grab this partnership interest can't. So by statute, and the statute is merely an embodiment of what was common law or what was developed by the courts, the remedy for plaintiffs in that situation is something called a charging lien or a charging order. So that plaintiff cannot take that partnership interest away from the party that has the judgment against them, but they can stand in their shoes to receive the income. Now, this is tricky. income is a funky word that most people do not understand. Most people think that income and cash flow are the same thing, and they're not. Income means tax liability. So with a partnership, with an entity taxed as a partnership, like an LLC or a limited partnership, there can be income with no cash flow. Because if the entity makes money, the partners are going to have the tax liability for that income, even if the cash stays in the entity. So that kind of income, by the way, when you have an income tax consequence, you pick up this income, you get what's called a K-1 that says you got this much income and you're liable for the taxes, but you didn't get any cash flow. That's called phantom income. So when we have this plaintiff who wants to grab the income out of this LLC, we're going to give it to him. We're going to deliberately incur transactions that trigger income, and we're going to give that plaintiff a K-1 and no distributions. So that plaintiff will end up having a tax liability for the income, but they won't get any cash. So that makes it kind of a poison pill. So the plaintiff doesn't want that. I've been through this many, many times with clients that have even gone through bankruptcy. And often the plaintiffs will say, do you want the charging lien or the charging order remedy? And the plaintiff will say, yeah, no, thank you. No, thank you. I see that one coming. And I've actually had one time, we had somebody who said, yeah, give that to me. And so we did. And later on they said, hey, I don't like this. Now I want to point out that there's a couple of cases out of, guess what, California, where there was a periodic regular payments that had been occurring over a long period of time where the member, who was a natural person, remember people have people problems, well, this person had a person problem, and they had a personal liability. And as soon as the plaintiff come and said, give me the income, the entity, the partnership said, yeah, well, we're not going to make distributions anymore. And the court said, because you had a pattern of making regular periodic distributions to that person, and the only reason you stopped making those periodic distributions to that person was because now they have a judgment against them. The court said, you can't do that. We're going to make you continue the distributions so the plaintiff can satisfy their judgment. So it's important, by the way, if you're doing these kind of transactions, that you not have regular, systematic, periodic distributions of the same amount. Distributions should be irregular, inconsistent, in different amounts, up and down, here and there. Now, another crucial thing that we see a lot of times that clobbers the asset protection, it gets people in big trouble, is they have this limited partnership and it's what we call naked. It's just barely formed with the governing authority in the state, but it has no governing documents. Now, by the way, if you don't have governing documents, there are statutes that kick in and apply because you didn't do your job. The lawyer that you created this with didn't do their job, or you went online and you bought one of these cheap, easy entities, but you didn't bother to finish it up and do the documentation. So if you have no such documentation, the statute fills in the gaps. Here's the challenge. The statute may not do what you like. It may do things that you don't like, and it may give your creditors rights that you don't want them to have. So it's far better for you to have documentation. And you can have a little bit of documentation, you can have piecemeal here and there, or you can have it fully documented. And you can have that documentation specifically designed to prevent the hostile third party from gaining access to the assets or getting control over it. And that's what a lawyer who knows what they're doing is going to do. Now, these kind of entities, whether it's a corporation or an LLC or a limited partnership, to work for asset protection, there's things they need to do consistently. File tax returns. They need to have business meetings. Now, interestingly enough, business meetings that are documented in minutes are mandatory for corporations. If you don't do it, that's a failure to comply with a legal duty, and that can actually be the means of penetrating the corporate veil and getting to the corporate assets. A lot of states do not expressly require that for LLCs or limited partnerships, but it's still a good idea. In the event of a lawsuit or litigation or a divorce or many of the challenges that end up being levied against these kinds of entities, If you have regular, consistent, periodic documentation that shows that not only you're a business, but you're acting like a business, you're conducting business in a business-like fashion, that helps you with all those things. Having such meetings and documentation also helps your business actually succeed and thrive, and you make more money. By the way, the IRS does not complain if you make more money and you're going to pay your fair share of taxes, but paying some taxes and doing the job of actually functioning like a business dramatically enhances your asset protection. I hope this video has been meaningful to you. Our firm is currently taking new clients, and the best way to get in with us is to get on our wait list. So click below and we'll get to you as soon as we can. We look forward to working with you.